Okay, here's a question for you. Could taking care of a little plant in a pot actually get you into serious legal trouble? You might think, no way, but you'd be surprised. The Kerala High Court just had to rule on this exact issue, and the case is pretty wild. It all started with 5 cannabis plants, a terrace, and a really clever legal argument.
So let's set the scene. And I want you to get this picture in your head. We're not talking about some massive secret drug operation out in the countryside. Nope. This whole legal showdown started in a much more everyday setting, which is honestly what makes it so fascinating.
All right, so excise officials get a tip, right? They go to search this rented building. And up on the terrace, they find not a field, not a garden, but just 5 cannabis plants, each one growing in its own little pot. They also grab some ganja seeds and a few dried branches. Now, for the officials, this probably looked like a pretty straightforward, open and shut case. But, as it turns out, the person they accused had a very creative defense ready to go. And that whole defense, the entire case really, balanced on this one question. Does the law actually care where you grow a plant? Is there a legal difference between planting something in a garden and just, keeping it in a pot on your balcony? It sounds simple, but the answer was going to set a huge precedent. This leads us right to the petitioner's argument. It was a seriously clever attempt to find what you might call a loophole in the law, specifically the Narcotic Drugs and Psychotropic Substances Act, or as it's known, the NDPS Act. So the entire legal battle really came down to this. On one side, you have the petitioner, who argued that the word cultivate specifically means, tilling the soil, working the land. He's saying since he was just using pots, it's not technically cultivation under the law. But on the other side, the state argued that no, cultivate is a much broader term. It means any conscious act of helping the plant grow, and it doesn't matter where you do it. But he didn't just stop there. He also threw in another argument, sort of a plan B. He claimed that since the plants hadn't actually produced any flowering tops yet, the part that's legally defined as ganja, then they weren't actually illegal. This move basically forced the court to get out its magnifying glass and look at the exact wording of the law. And to figure this all out, there's only one place to go, the actual text of the NDPS Act. Because the answer here wasn't going to be found in a gardening manual. It was buried in legal definitions. So first up, what does the law say a cannabis plant is? Well, the definition is incredibly simple and broad. It's just any plant of the genus cannabis. That's it. It doesn't say anything about its size, its age, or whether it has flowers on it. If it's a cannabis plant, it's a cannabis plant, period. Now, compare that to the definition of ganja. Here, the law gets super specific. It defines ganja as only the flowering or fruiting tops of the plant. So by having these two separate definitions, the Act makes it really clear. An illegal cannabis plant does not need to have produced ganja to be considered illegal. And just like that, the petitioner's second argument completely falls apart. Okay, so with that secondary argument out of the way, the court could finally focus on the main event. What does it really, truly mean to cultivate? And wow, this quote from Justice C.S. Diaz just says it all, doesn't it? He left absolutely no room for doubt. The ruling says that to cultivate covers any act of growing the plant as long as there is mens rea. That's the legal term for criminal intent. And then comes the knockout blow, whether such cultivation is carried out in the earth or in a pot. Now, the court didn't just pull this definition out of thin air. They went and consulted legal dictionaries. And it turns out the word cultivate is huge. It covers everything from traditional farming and tilling to simply raising, growing, or even just nurturing a plant. The petitioner's very narrow definition just couldn't stand up to that. So here's the bottom line, the thing that really matters. The court decided that the where is irrelevant. The medium, whether it's soil in the ground or soil in a pot, it just doesn't matter. What makes it a crime is the conscious decision, the deliberate action of helping that illegal plant grow.
And with that laser focus on a person's intent, the final verdict in this case was pretty much inevitable. The High Court shut it down. The petitioner's request to have the charges thrown out was dismissed. The case against him is going to trial. That clever loophole he tried to argue for, the court officially slammed it shut. All right, so what are the big takeaways from all this? First, in the eyes of the law, the word cultivate is way broader than you might think. It's not just about farming. Second, intent is everything. It's that conscious choice to grow the plant that really forms the heart of the crime. And finally, and this is the most direct point, if it's an illegal plant, the law makes absolutely no distinction between growing it in a giant field or in a tiny pot on your terrace. You know, this case is just such a great reminder that words we use every day can have totally different and much more powerful meanings in a legal context. It really makes you wonder, right? What other normal, everyday words do you think have a completely different and maybe much more serious meaning in the eyes of the law?